Georgia lawyers Bob and Irreverent D talk law. Listen up for stories about how things really happen in our legal system. Who are these guys? Dwayne Singleton, Irreverent D, is a criminal defense attorney in the state of Georgia. Benjamin O. Benson, aka Bob, is a personal injury attorney in Atlanta. On today's episode.
All right, here are the facts. The news article has a picture of a person slipping on a banana, which is telling. It says a $1.5 million verdict awarded by Gwinnett County State Court in March has been vacated because of a lawyer's social media posts. A series of social media posts from Pumu indirectly regarding the dispute before, during deliberations, and after the trial resulted in the verdict being nixed.
Now, sit back and take a listen as Bob and Irreverent D talk law.
All right. Thank you for joining us. Welcome to the Bob and Irreverent D Talk Law podcast. Make sure that you join the hundreds of subscribers in being on the winning team of subscribers to our podcast.
Millions. We're
Millions.
thankful for the millions of followers we'll have in the future.
Yes. We are winning.
We are winning.
We are winning, and we're gonna keep winning. We are joined today by the illustrious Ed Wynn from Slappy and Sad. Ed is a dear friend of mine. I used to work at Slappy and Sad. Slappy and Sad, not a joke. It is the actual name of the law firm. They are outstanding lawyers. Both Dwayne and I have had long-standing relationships with the Slappy and the Sad. They're the most outstanding trial lawyers. I mean,
and they do win.
They do win.
Yeah,
that's right. Ed wins too.
That's right.
And we're also joined by our stalwart partner, Dwayne Singleton of the Dwayne Singleton Trial Lawyers Group in Griffin, Georgia. Recently
Atlanta.
Rebranded.
That's us.
Listen, do him a favor. First, call him because he's the great trial lawyer. But second, after you've called him, do a Google search for Singleton Trial Lawyers Group in Griffin. We really need to get his search optimization up.
I didn't know that changing the name would affect where you land
on it.
Yeah.
Turns out that whole mystical SEO thing, it's a real thing. Yeah.
And if you're injured in a personal injury accident, make sure you reach out to Bob Law Firm here in Atlanta. Ben Binkson, one of the greatest trial lawyers in the world. He doesn't settle.
Well, we settle if it's right.
Right. Well,
we decide on what it needs to be. That's the way I think.
See, I like that, though. We don't settle, and neither should you.
I mean, I don't like the word settle because it suggests that you're giving up. Right? What we do is we decide what it should be, and then we just keep driving until it is. Like we materialize what the outcome needs to be, and we just keep pushing until it does. Anyways, so today we're going to be talking about social media and why you should be careful on social media, Dwayne. All right. We talked about let's talk about the news.
And now, the news.
Today's news, we're talking about a verdict in Gwinnett County that was overturned by a judge because the plaintiff's attorney, posted on social media about the trial during the trial.
Now, he wasn't posting, though, from the courtroom because that would get you in big trouble.
Yeah,
right?
No, he wasn't sitting.
He wasn't like doing selfies and like doing a live stream.
Right.
He wasn't like this plastic surgeon that just recently has been in the news. It was dancing and doing TikToks during the surgery.
Wait, that happened?
Oh, you haven't seen this?
Yeah, they took her license.
The civil suit just started, I think, here in Georgia yesterday for her, but she lost her license recently.
So tell us we're going to pause about the trial because this is really fascinating. What happened?
Okay, well, apparently there was a plastic surgeon, and she was filming, live, Facebook Live, Instagram Live, something like that, where she would field questions actually during procedures that she was performing on patients.
Wait, hang on. Time out. So she's like doing this number right here, like, and now I'm doing the nip tuck like thing.
Essentially. And here's the
Wow.
thing that's
Okay.
confusing me. I'm
Can you do
I'm
that?
getting fuzzy on the details. I
Right.
mentioned a second ago there's a trial that just started yesterday. I actually think there's 2 different doctors that have gotten in trouble for this.
Okay.
One of them's in Georgia, but then there was one recently that was in the news, I want to say up in Illinois, but the same thing. And this one had actually already been chastised by the medical board to stop doing it and continued to do it.
Right. And I think she like nicked somebody's intestine or something.
She had a malpractice case or two.
Yeah.
This
I
is the one
think,
here in
if I
Georgia?
recall.
No, this
Yeah.
is the one I think in
The one out of state.
North, right.
So,
She
okay.
had
Got to
like-
keep track of these 2
She had
different
like a million.
live streaming doctor cases.
She had like 1 million followers on TikTok or something. Just like
Wow.
insane.
So, I mean, what's wrong with that though? If your patient agrees, like we're consenting adults, right? Like if I want to do like intestine porn and let people like see my guts be like explored by a doctor, like what's wrong with that?
It's a question of competency, I think, right?
I mean, because I asked people after,
Do I need to state the obvious? Come on, man.
so I can't be dancing. When
Like,
I'm-
no.
I know this isn't a show for lawyers, but I mean, I think your audience is smarter than that.
Yeah. So the medical board, right? There's a self-policing part to it, right? Like we don't want lawyers to be doing crazy, stupid things. And so we have the Georgia bar where we say, okay, look, you can't do that. This is our self-policing force. Like whatever it is, we don't want you doing TikTok videos while driving 100 miles an hour down the road and filming a commercial, right? Like, and so the medical board, I think in that circumstance with the doctor could step in and say, look, we don't want you doing that because it makes the medical profession look bad from a self-policing standpoint. But like, what's illegal about it?
Well, it's like us lawyers that we have certain types of conflicts of interest that can't be waived. Sometimes clients can say, I don't care about that. I
Right.
still want you to represent
I'd never
me.
sue my mom, blah, blah, blah.
Right. I still want you to represent me.
Yeah.
But there's some conflicts that even if the client completely consents, the bar has said in rules, sorry, this is not waivable because it's going to reflect bad on the profession.
Right.
And I would think that live streaming during your patient's medical procedures isn't the best look for the medical profession.
Right.
might be a problem.
But maybe not illegal, but certainly like bad for doctors.
Unsafe, I would say.
Yeah.
Well, like after I win a case, I'll ask the client, I'm like, you want to stand outside? We'll take a picture. And if it's like a rape case, they're like, no picture.
Yeah, maybe
please.
not.
Rather not, but if
Yeah.
it's a, regular DUI or something like that, or a marijuana case, they love being on there. They're like, yeah, I'll take a picture,
So do you post them?
Yeah. I post them to my
Do
social
you get in
media
trouble and have your verdicts overturned?
feed. I hope not.
Okay. Not yet.
I hope not. But I have had, a judge comment on something that I had posted on my social media feed months prior to trial. I was talking about jury nullification. And he said, take
Ooh,
it down.
Don't ever talk about jury nullification.
He was like, take it down now.
Ooh.
And so I took it down.
and took it to
But,
because you didn't want to have to bring your toothbrush to the next court appearance, right?
well, right or wrong, he's still the judge, right?
Right.
But, I probably should have drawn a line in the sand and took one for the team, but, I
Yeah.
chose not to.
But like sometimes discretion and valor and some
Sometimes
kind of weird thing.
winning the battle and the war
Yeah.
is important.
Sometimes it's best to you can best serve all of your clients if you're not
From
in jail.
not disbarred in jail.
Right,
Right.
exactly. All right, so now let's get back to the news article. So what happened was this plaintiff's attorney during the trial, not as you say, sitting at the trial and like posting, right? But at home working on the trial, he posts on his social media site that he has to tell 3 lies actively in the course of a trial.
We call those legal fictions.
Legal fictions.
They're created in almost every trial, right?
Maybe this episode should be about evidence,
Right.
right? But at any rate, the 3 lies he says in a motor vehicle accident case are: 1, we can't talk about insurance, that the defendant has insurance, and 2,
Because the rules say you can't. Right?
that's right, we have to essentially hide it from the jury.
Because you're not suing the insurance company in this case. You're suing the person that caused the accident.
That's right.
Right.
The second lie was that he's not allowed to tell the jury that the defendant in that case, who his client is going against, was arrested for causing the wreck. And the third is that he couldn't tell the jury that the defendant offered to settle the case, right?
That's all pretty common.
This happens all the time.
Very common.
Ed, talk to us. Like, why is it that we can't talk about insurance during an auto accident case where everybody knows there probably should be insurance?
Yeah, why can't we say there's $100,000? That's all we're asking for. Just give us the insurance money.
Well, there's a couple reasons, but first, what's important is it is a two-way street type of rule.
Okay.
So, in other words, you can't talk about the fact the defendant has liability insurance that could pay the judgment or the verdict that the jury is going to award. But you also can't talk about the fact that the plaintiff might have health insurance. In other words, the jury is not told that he or she does not owe all those medical bills. That, it's a windfall to them because insurance has already taken care of them. So if you award those medical bills, we'll get it. They're not told that. They're also not told the liability insurance. And of course, with a lot of people don't have health insurance. So that would be one reason we keep that out, because we don't want the jury guessing one way or the other, whether they have it.
Right.
But the big reason for the policy is that the jury is supposed to decide the case based on the evidence and based on the law, not about whether there's some pool of money out there that's going to be easily able to pay the recovery and, some big giant corporation or insurance company, can afford to absorb that is going to be writing it, because that would obviously, influence the jury potentially, in theory, one way or the other. Now, I say in theory because practically speaking, most folks know that there's insurance.
Right.
You have to have car insurance if you
Can we
drive.
pause there for a second? It's not just that they know, but at the beginning of trial, the judge says, when he's checking the jury pool, sorry, not the beginning of trial, the beginning of jury selection, right? The judge looks out in the entire jury pool panel and says, is anyone here a stockholder in State Farm Insurance Company, right? Or is anyone here part of Allstate Mutual or whatever?
That's right.
Like, I mean, it's announced almost at the very beginning of jury selection, like which insurance company you're not supposed to know about, right? Like, how is it that we can expect a jury who's heard that at the very beginning to just completely wipe it from their brain? Do we know?
Well,
I've always wondered about this.
I think that's the kind of the debate.
Yeah.
Are you really pulling the wool over the eyes with this rule? But I think the really important thing about the rule is you don't want a lawyer from either side coming in and making the case about how the judgment gets paid, because the question for the jury is, should there be a judgment, and how much should that judgment be? They're not to concern themselves with extrinsic factors like who pays and that sort of thing.
All right, so test my theory out. Dwayne and I were talking about this in a recent podcast where I was kind of using this illustration. Look, as lawyers, we get so ingrained in the jury determining the outcome of the trial that really maybe we should be teaching the jury or encouraging the jury to really think of themselves as umpires. Like, I'm calling whether they're out or they're not out, not the entire outcome, because the entire outcome has to take into account all of those other things that they can't know about. What do you think of that? He's like, I do not like that. That's a terrible illustration.
Well, it's funny. I think probably any rule of evidence is going to probably confuse the average person. I'm sure that one thing that you've heard after lots of trials is, why didn't we hear who got the ticket?
Right.
Yeah. Right.
That, to most people, that's the only thing the case should be about.
Sure.
When they walk in and they don't know about this rule of evidence. And you have to explain to them, we don't want you to take the officer's decision about who was at fault, because he could be wrong.
How is that even possible? That's not possible.
We want you, the jury, your peers, to make the decision fresh, because, nobody would be able to get their day in court if everything was already decided in the court of public opinion or decided by
the police,
folks that weren't the judge and the jury.
Well, not just that. Dwayne, we have that come up quite a bit where the clients, our clients, say, well, the police found them at fault. Like, why is there even a question? And of course, we tell our clients, this isn't even in trial. This is months and months before a potential trial. We say, well, look, all the police did was come and ask people what happened. They didn't see it.
And sometimes they don't ask everybody what happens because your client's in an ambulance going to the hospital, right?
Right.
Yeah.
Right. Yeah, that's right.
And so they get the statement that they put in their report from the at-fault driver, and then you come back and you can have to litigate that.
Right. So the flip side of that, if I was arguing on the defense side, I would, just to amplify your point, Ed, like, I don't want the jury to be thinking, oh, well, it can be paid by some kind of, insurance company, right? Like, I don't want that out there. That's why the defense wants we don't talk about insurance, right?
So what he's really in trouble for here is that he kind of pulled back the curtain and let everybody see what was behind there, and he's not supposed to in the middle of a trial. But what about if you post this information on the internet or you put it up on a social media platform and it's just there?
What if I posted this same thing tomorrow and I'm not in a trial, right? Like, that's the same. It's still the same issue. I'm potentially tainting a jury.
But you have, in like criminal cases, you've got the sheriff like holding them up in front of the camera, posting them on their Facebook page as soon as they arrest somebody and they're innocent. And then you've got the DA's office that wants to make a comment about it and do a press conference, still innocent.
Right.
And then you ask the judge to remove the case to another county. He's like, no, we're good here.
Right. Yeah. And the DA is having a press conference.
Right.
Yeah, exactly.
Out in the front going, we will get justice for, baby so-and-so or whatever. Yeah.
Exactly.
Yeah.
Now, in premises cases, though, like, do we care about whether insurance is talked about? Because, like, it seems to me like if you have a case against, apartment complex for not providing security, the jury would kind of know, well, these guys have money, right? Like, I mean, do we care about insurance in those circumstances?
And for our non-lawyer followers, what is a premises case?
Premises liability case is basically when a person suffers an injury on a property that is owned or occupied by someone else due to some condition or activity on that property. So a slip and fall in a store is the big example.
Right.
But also it could be, a trip and fall down stairs that are not properly built to code. It could be any number of things, but property is generally the key in that you're a guest onto that property.
Now, just because I get hurt on somebody's property, does that mean I have a case?
No, I mentioned guests on the property because there's types of guests, and there's even really the class of trespassers as well, something we kind of learn very early in law school and torts when you start talking about premises liability cases. So no, the answer is like everything else, there is a specific burden of proof that you have to prove in a premises liability case. And it can be a little bit more difficult in your car case because there's not a premises liability police force that goes around and performs a lot of investigations. Typically, most of the evidence is going to be in the hands of the defendant, your surveillance footage and that sort of thing. So those cases can be very evidence intense.
How do you get to that stuff? Like if it's
typically you got to sue. Yeah. I mean, if they essentially, it's their property, that video is their property. Now, there are measures that you can take, as you know, to make sure they preserve that video, or at least ensure that there are penalties down the road if they're caught not preserving it. Or if it disappears, quote, unquote. Okay. That's spoliation of evidence for folks out there. But, when you are in the position where they have the surveillance video, they know the employees that could have been witnesses, you don't have access to those unless you have subpoena power, which you only get through filing a lawsuit.
Can't you? Okay,
they can voluntarily give it to you, but that's
and clients get upset with me all the time because they're like, just subpoena it. I'm like, there's no case yet. Right. I can't just go and get somebody's security camera off the side of their house just because I want it. Right.
Yep. I had a long talk with an attorney who represents a, let's say, well-established grocery store in the Georgia area. And I asked him, this was after we had filed a lawsuit, but I said, look, we could have avoided having filed a lawsuit.
Just let us see
if you just let us see the video so that we could and determine like what exactly happened. And he said, Yeah, I get that. And plaintiffs' attorneys complain to me about that all the time, but you got to understand from the commercial establishment standpoint, right? There are other people in that video that have privacy rights that ought not to be violated, right? There are other people who, didn't volunteer to be watched on video because just because your client allegedly slipped and fell. So I get that, right?
I don't.
What's your objection to that?
I mean, I know it's a private business, but it's open to members of the public, and it's surveillance. I'm sure there are purposes that those videos are being used where, the privacy right may not be that interested to the corporation, such as a loss prevention investigation. I don't see them denying that footage to the police that's investigating the guy they just had apprehend. The store.
And they pick you up.
That's a good point.
We're worried about. We don't want you to know who those people on aisle 4. Which, by the way, I mean,
they're in public.
They're not putting it on the screen
public.
over here by the Battery at movie night. People are going to be like, "That's Jim,"
But I mean, some
it's
companies
being disclosed in a lawsuit for a very limited purpose, and so it sounds like an excuse to me.
Some companies have like facial recognition software, and you've been told to be off the property, like they ping you in the parking lot and know when you walk in the store.
Really, this happens. The Chat GPT's got them.
One particular store that has lots of surveillance. Knows everything.
Knows everything.
They have you from the time you get in your car. They can zoom into your hands. They follow.
Are you talking about the Apple Store again?
That's like casino level surveillance.
It is. Yeah. Once they know who they're looking at, it follows every place that they're in the store.
Really? Wow. Yeah, Ed, I'm so glad that you mentioned that because about loss prevention because, I've always just assumed that they have the video there to prove my client's case, right? for safety, but really,
no, they gave it to lock my clients up.
they have that video surveillance there so they can see if people are stealing milk, right? That's why it's there. Yeah. Okay. Gotcha. All right. So the second thing that he says is that he was back to the news item, by the way. He's prevented from telling the jury the defendant was arrested after the accident, right? The plaintiff's attorney complains about this. I'm not sure that I'm so indignant about not being able to tell the jury that the person was arrested. Like, why is that an issue? Anybody want to take that up?
Well, I think once again it goes to the officer making the determination whether or not somebody is responsible for an accident or not. Right? Because he's already made the decision to arrest, and you're trying to get back to the jury as the fact finder.
There's a phrase that we're all familiar with, but I don't know that lots of folks out there heard it because it's not something I think that makes most of your courtroom TV and movie dramas. But it's
on the podcast all the time.
That's what we talk about here.
But that's the province of the jury. You hear that a lot.
Yeah.
Or the exclusive province of the jury. And that means the jury is the exclusive decision maker on certain things. And so we don't want them basing their decisions or having their decisions made in advance by those that aren't sworn onto that jury and don't hear all the evidence. Because the police officer, he may not have heard the testimony of the accident reconstructionist that the parties hired.
That's right.
Found evidence that perhaps he did not find at the scene. We don't want to eliminate the possibility that, there's other evidence and things like that the jury could reach a different decision than somebody else who was making that decision in a different context.
Right.
Possibly without all the same information.
Because the officer could have written somebody else a ticket and held them responsible, but at trial, the jury finds that the other party was at fault, right?
Well, think about it. What if an officer writes someone a ticket and then that person is acquitted on the ticket?
Right.
Well, then you have two decision makers.
Sure.
So how does the jury pick there? And so we decide that, we're just going to give the jury all the evidence under the rules of evidence about what they can look at and can't.
Right.
And then they make the call. And we're not going to let, the officer could take the stand. He could talk about what this witness says, what the party said. But, we're not going to let him get up there and point the finger and say, that's the person that caused the accident was at fault.
Now, I find sometimes, though, like in criminal cases especially, where the officer's been given this long list of, you can't say this word, you can't say this, you can't say this, you can't talk about this. And then we get to crossing him. and he looks like a liar
because he can't say certain
because
things.
he doesn't know what he's trying so hard to think through what he's like every time you can just see him processing.
Right.
You know, and sometimes criminal defense attorneys that are skilled might take advantage of that.
Yeah.
You know, by asking him rapid questions and.
That happened in a civil trial of mine where my client almost caused a mistrial, and it wasn't her fault because she was being cross-examined by the defense attorney, and the defense attorney was asking her about this prior accident, and my client was saying, well, yes, I was in this prior accident, but it wasn't that big of a deal. And of course, the defense attorney's like, not that big of a deal. Wasn't your car totaled? And my client said, well, yeah, but that's just because the insurance company, blah, blah, there was
Right.
the insurance company
Because the car was
said,
worth $1,500.
right, the insurance company said the car wasn't worth fixing, right? And then all of a sudden, boom, we all have to go up, get hauled up in front of the judge, and the judge say, your client just used the I word. And I'm like, what? I mean, what am I supposed to do? Right? Like I could not have possibly prepared her for that question. I don't like.
Right.
So like, it can happen. Ultimately, what I argued was, look, I love you, Mr. Defense Attorney, but you introduced insurance into the question. You just said totaled, and totaled is an absolute insurance industry term. Right, that only means something in the insurance industry. Right. I don't know how you could have expected her to say anything other than like
to explain it.
To explain.
And there are other exceptions where you can get liability insurance in.
How? What?
Well,
I missed it. What is it?
There's an example. Let's say you asked me about premises liability cases. Let's say you get injured at my strip mall. And you sue me, and I say, I actually don't own this strip mall.
This is not like an adult mall. We're talking about like a place where there's a bunch of different shops.
Old-fashioned place where you shop before they had, Amazon.
All right, gotcha. Yeah, okay. All right, got it. Yeah. Not a gentleman's establishment mall.
No.
Okay,
no,
gotcha.
No, but let's say I own a business, if that works better for you.
Okay. All right.
Someplace where goods and services are provided.
All right.
And you're injured at that establishment, and you sue me because you believe I'm the owner, and I claim I'm not the owner.
Okay.
But you have evidence that I bought an insurance policy on the property.
Okay. Yeah. Sure.
That is something a judge is probably going to say, you're denying this is evidence that, you actually do own the property, because why would you take insurance out on it if you didn't?
Right, because ownership in that case...
Maybe even list you on the policy as owner insured.
Yeah. In that case, whether you own the property is an issue in the province of the jury. Right. And they have to make a decision. Of course, they should be able to see that. Yeah. Very good. All right, let's touch on the third one real fast before we wrap up. He says also the third lie is that the defendant offered to settle the case, which showed that the defendant believed they were at fault.
Can't talk about settlements.
You can't talk about
settlements. Pre-trial negotiation. I can't say. Before trial, the DA offered me, 1 year in jail. Now he's asking for life.
Right. Why is that important?
Why is evidence of settlement negotiations and demands?
My clients ask that about all
permitted?
the time, right? Yeah. Why? Like, what do you say when your clients ask you why they offered to settle for $10 billion? Like, why can't we say that to the jury?
Rationale is really not that different than it is on why we don't allow the insurance evidence itself to come in, which is that we don't want the jury dictating what the amount of their verdict is based on the parties' numbers, because the jury has to look at the evidence and decide from that what the value is. And what the parties do in negotiations, which are usually intended to be confidential and almost always are per this rule of evidence.
Sure.
Confidential, don't come into the jury. That is one of the reasons that we don't want the jury knowing about that stuff, because then they're not looking at the evidence.
Are you starting to rethink my illustration about about the jury determining outs and outs are being safe or out versus like the outcome of the game? Like, it just seems to me like it's really like we really ought to be encouraging that kind of mentality of thinking, look, you're not here to determine the outcome. You're here to determine, is there fault? Are there damages, and or whatever. Like, I don't know. It's something I'm kind of developing. Think on it. when you come back, we'll go over it again.
All right.
All right. Well, thank you for joining us. Make sure that you subscribe.
Give us a thumbs up.
Give us a
click
thumbs
the bell.
up.
Thanks for having
right.
me, guys. Thank you.
Also, thank you for coming on the show. We sure appreciate your time. Also, make sure to listen. We've got to help our guy Dwayne out, Irreverent D. Make sure you go on the Google and type in
The Google.
Yes, go on the Google. And
Like us on Google.
Yeah, type in Singleton Trial Law
Group.
It'll
be way down at the bottom.
Not anymore.
Way down.
Not anymore. After our hundreds of subscribers do this, you will be quickly back up at the top.
That's right.
Thanks for joining us.
Thanks for listening. Tune in next time when Bob and Irreverent D talk law.